Good morning, everyone. I'd like to welcome everyone here in Carson City and those in Las Vegas, and of course, anyone watching online to Assembly Judiciary. Committee secretaries, please take the roll.
Assembly members Cole. Here. Dahlia. Here. Gonzalez. Here. Gray. Here. Hanson. Hardy. Here. LaRue Hatch. Here. Marzola. Present. Moore. Here. Nadeem. Present. Orenlicker. Roth. Here. Urich. Here. Chair Miller.
Here. And please mark, oh, Assemblywoman Hanson is here. Please mark Assemblyman Orenlicker here when he arrives. And with that, I just want to mention a few housekeeping issues. Of course, just a reminder to turn off any of your electronical devices. Also, we will have public comment at the end of today's meeting. We ask that anyone making public comment or testifying on a bill keep their comments to 2 minutes, asking all speakers to please remember to state their name before they speak and spell it the first time so we have it correct for the record. We have 2 bill presentations today. I'm also reminding folks that we ask that you keep your bill presentations to 15 minutes each. Our phone number today for those wishing to call in to participate is 1-888-475-4499, and the meeting ID is 895-1093-3520. And of course, you can locate that on the agenda that's posted on Nellis today. With that, we will go ahead and open our first bill hearing. Today we are hearing Assembly Bill 13, which revises provisions relating to criminal justice. Okay. Are you presenting Assembly Bill 13? Is it? Who's presenting it?
Both of them are the
Oh,
courts.
okay. All right. All right, folks, so here's what we're doing. Because what we don't do today, we'll end up doing on a Saturday morning sometime soon. So I figured the choice would be to go ahead and push through this time. And yes, scheduling snafus happen sometimes. So we are going to take our bills out of order and begin with Assembly Bill 18. And Assembly Bill 18, what does Assembly Bill 18 do? It revises provisions relating to the electronic filing of certain documents. So I will invite the bill presenters to come to the table. And we have our own legal, Ms. Carly O'Krent, assisting today. And so I just ask that you introduce yourselves, again, spell your name for the record. And so whenever you are ready, and again, we ask that you keep the presentations to 15 minutes. Whenever you are ready, please proceed.
Thank you, Chair. Catherine Stocks, State Court Administrator for the record, Katherine Stocks. Thank you for having me here this morning, and thank you for your flexibility. Yes, we have our normal person, Mr. McCormick, is out from surgery, so I am covering AB 18 and apparently also 13 today. So appreciate your flexibility, as I said. AB 18 is a cleanup bill. As part of the court's strategic plan, we have been revising outdated Supreme Court rules. And as part of that, you will see the document that you have is that the court replaced our electronic filing rules for updated and modern practices, recognizing the reality of how e-file works today. And part of that was updating the definition of electronic signature, or e-signature. It is an electronic identifier created by computer, intended by the party using it to have the same force and effect as the use of a manual signature. So this bill before you today is the cleanup provision that essentially replaces what were requirements of like a JPEG of a signature instead of an electronic signature. And all of the different sections just address various portions within the NRS that have the older version of the definition of an electronic signature. And that's essentially what this bill does. I am happy to answer questions.
Give members a moment to formulate their questions. Assemblymember Gray?
Thank you, Madam Chair. With these electronic signatures, is there going to be some kind of a verification process through like a third party or something, like when you do your taxes or other legal documents?
Yes, through that, you're actually doing a certification that you are the intended signatory. It depends on the individual case management system or e-filing system, but all of the standards that we have within the electronic filing rules meet national best practices as is, and we intentionally have it in here that the requirements for that authentication, they amend as the national best practices amend instead of trying to set them and then going in and amending on a regular basis.
Members, any additional questions? Okay, well, with that, I will go ahead and open it up for testimony in support of Assembly Bill 18. So if there's anyone here in Carson that would like to come forward and testify in support of Assembly Bill 18?
Good morning, Chair Miller and members of the committee. For the record, my name is Taylor Avery, and I'm the Manager of Political Affairs for the Vegas Chamber. The Chamber supports Assembly Bill 18, allowing certain legal documents to be submitted with an electronic signature rather than an image of a signature will streamline the submission process and make the courts more efficient, efforts which the Chamber strongly supports. The Chamber also supports efforts to make the courts more easily accessible to the public. Thank you for your consideration.
Okay. Thank you so much. Is there anyone else here in Carson City that would like to testify in support? Okay, is there anyone there in Las Vegas? Not seeing anyone? Then broadcasting, open the lines, please.
If you would like to testify in support of Assembly Bill 18, please press *9 now to take your place in the queue. Again, if you'd like to testify in support of Assembly Bill 18, please press *9 now. Chair, there are no callers wishing to testify in support at this time.
Thank you so much. Okay, with that, I will welcome the bill presenter up for any final comments. Okay, thank you. Okay, then I will go ahead and close the hearing on Assembly Bill 18. Next on the agenda, we have Assembly Bill 13. Assembly Bill 13 revises provisions relating to criminal justice. I will welcome the bill presenters up And so again, just a reminder to say your name and spell it the first time for the record. And we ask that you keep your presentation to 15 minutes. Looks like we may keep today's meeting to 15 minutes, so. Right. But whenever you are ready, please proceed.
There we go. Okay, I am Chief Judge Lynn Jones of the Second Judicial District Court. Easy spelling, L-Y-N.
I'm sorry, Judge.
It's okay.
I'm out of order. I forgot to ask for opposition. I need to close this. I'm
Please.
going to close. Yeah, she's like, please. Okay, it's like Freaky Friday here. Okay, so I'm going to close the hearing on Assembly Bill 18 and reopen the hearing on Assembly Bill 13 because I did not ask for opposition or neutral testimony. Is there anyone here in Carson City that would like to oppose Assembly Bill 13? Not seeing anyone in Las Vegas. Broadcasting, will you please open the lines?
If you would like to testify in opposition to Assembly Bill 18, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in opposition at this time.
Thank you. Is there anyone wishing to testify in neutral here in Carson City? Not seeing anyone, and there's no one in Las Vegas. Broadcasting, will you open the lines?
If you would like to testify in neutral for Assembly Bill 18, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in neutral at this time.
Thank you so much. Then I will go ahead and now again close the hearing on Assembly Bill 18 and reopen the hearing on Assembly Bill 13.
Good morning.
Good morning.
I'm Chief Judge Lynn Jones of the Second Judicial District Court, easy spelling, Lynnnejones. I'm honored to be before this committee, and I want to just thank all of you for all the work you're doing during this session, and it appears that it's a robust session. I'm here to speak about the proposed amendment, or the AB 13, and give you some context and logic. I think that it is, genesis is to ensure that conditions of probation are met, including fees and including restitution, which I know is very important to all of us and to our community. This bill allows that an independent action may be filed to enforce the provisions of a judgment which impose a fine fee assessment or restitution. The portion of it that I think is probably the subject of the greatest discussion today is the proposal that we be allowed a general discharge to probationers. Currently, as written in the bill, there is honorable and dishonorable. And I want to focus on a couple of things. One, the language actually provides for an honorable. It isn't simply dollars. It actually is, they have to fulfill all of the conditions for the entire period of their probation. So let me give you an example. Let's say that Hulk, Black Widow, and Iron Man had a portion of their life that they were on probation, okay? So Hulk is given conditions of probation. In addition to, all of them are, as a matter of fact, and those conditions include you must report in, you must apprise of your residence, you may not change your residence without permission. You may not possess or use any alcohol. You may not possess or use any controlled substances, including and drug paraphernalia, including hypodermic needles. You must not possess any weapons. You're subject to search at any time. You can't associate with persons with felony histories without approval. So those three are not going to be superheroing together, right? You must follow the directives and conduct and the laws applicable to you. You may not travel out of state without permission. You have to remain employed actively seeking employment or vocational training or education to increase your employment opportunities, and you must meet all your financial obligations. So the picture of probation is bigger than financial obligations. And so the person, Hulk, let's say Hulk did everything right, realized, he had a future, tough to wear clothes in the future, but he has a future and he does it right. He checks in, never goes out of state without permission, never has any positive drug tests, pays every dime, including restitution. Hulk deserves an honorable discharge. I think we would agree. Black Widow starts off a little bumbly, kind of doesn't, maybe has a technical violation, doesn't quite follow all the rules of her officer, chooses not to get a job. Officers saying, you need to do 5 applications. But in the second part of Black Widow's probation, she sees the light, turns it around, gets a job, is able to pay some, maybe not all of her fees, but kind of brings it home at the end, right? And then we have Iron Man, who just doesn't care about probation, doesn't do anything, is subject to revocation, obviously temporary, and then at the end, dishonorable, right? And what comes to it. So what do we do about Black Widow? Black Widow doesn't really deserve a dishonorable discharge, and that demeans Hulk's performance. But Black Widow brought it home at the end. She doesn't really deserve a dishonorable like Iron Man. There has to be something, and this is what you trust, our third branch of government, and our discretion to say, Black Widow, kudos to you that you brought it home. We want to inspire you. We want you during the periods of probation that the legislature has designated. This is where we want you to be. We want you to be rehabilitated. But under the language of the statute, she didn't fulfill all of her conditions. As a judge, when she brings it home at the end, do I want to say, oh, by the way, that doesn't matter? You get a dishonorable discharge. Or do I compromise Hulk's perfect performance and give Black Widow an honorable discharge? And that's what we're asking for. We're asking for you to let the judiciary exercise its discretion to have a middle ground that is appropriate for many, many probationers who don't run the perfect program. And it isn't just about finances. Now, the bill provides that if there is financial hardship, that we have some discretion. So you have entrusted it in part. But I think that in judicial fairness, that we need another avenue. And that is where this bill comes from. I invite your questions.
Thank you so much. And I'm not sure who told you that the chair was a raging Marvel fan.
Oh, well, I was going to use the Flintstones, but I thought I'd date myself.
Oh yeah, that really would. I'm also a Flintstone fan as well. But yes, and this building has kept me from seeing the latest Captain America movie, so nobody tell me. But and I use Marvel to I used to teach English with for story, plot, and diagram, and all the subplots and everything. So it's great working with 11 and 12-year-olds who also love Marvel. So I appreciate that, Judge. With that, do we have any questions for this morning? I see a question from Assembly Member Urick.
Thank you, Chair, and I appreciate the presentation and the superhero analogies. It makes it more entertaining to sit here and listen to that type of presentation. I'm not fully aware of the consequences of these types of discharges, and so I was hoping that maybe you could help us understand, like, why are we doing this, and what are the consequences between an honorable, dishonorable? Now, what is this going to do? And then related to that, just hearing this and not fully appreciating and understanding that there might be situation, according to the example that you just gave, wherein somebody fails to pay restitution to a victim. And while I appreciate the cause of action that now can be brought civilly to recover some of that, My concern is, are we shifting a burden back onto a victim to go and follow up if we're disincentivizing individuals from paying full restitution to avoid the consequences that you're going to share with us, and then pushing this burden back onto individual citizens or victims to pursue the ultimate restitution? Can you just kind of address those issues for me, please?
You know, it's interesting. You read my mind about when I was reviewing the earlier portion of this bill. One of the things that I would say that might be a area that could be refined is to indicate who can bring the independent action if one is brought. I'm not sure that any public agencies have the staffing to do it. A victim can bring, depending on the type of crime versus if it's also civil action, can do it anyway. But I think you're right. That needs to be clarified to make sure that there isn't a shift to victims. And I think that one of the things that I've noticed, particularly about this session, is kind of cognizance of sealing and the importance of restitution and being able to give those who have committed a crime and should be given a new chance with sealing. And I think some of this is the overlay of those different bills and the practicality of what we do when we're on the bench. Because the reality is, I digress for 1 minute before I get to the consequences. Should a person who has $300,000 in restitution have their record sealed? Right? I mean, there's an overlay here of everything that's coming before this committee. And that would be one, I was going to do this in my closing remarks, but that is one thing I would just really ask. There's a lot of brain power here in this committee, and to really take a look and shift the paradigm. Why is it important for us to have a general discharge as opposed to the defendant or the public defenders? Why is it important for judges to continue to have the third branch discretion? And look at it from all sides. So let's talk about in the bill as it is, and it's kind of interesting. It's tough to read because sometimes it says they can't get this, right? So one of the things is if you're discharged from probation under subsection 6, you get restored to all of these rights. If it's a dishonorable discharge, it's more limited. And if it's a general, if we're granted this discretion, we have our choice to determine. Because, maybe I think Black Widow, who brought it home at the end, isn't totally entitled to an honorable, but should be entitled to some benefits in a general and shouldn't be precluded by a dishonorable. So if you look in the statute as this body enacted, it lays out the consequences, and hard to read, right? And you have to read it backwards, and then you have to look at all the other statutes. And I think that we have to be cognizant of this day and age and people getting new beginnings, but honoring those people that really took their probation seriously, that really did it. Not the Ironmans who says, I'm just going to do my time in probation, I'm not going to pay anything, and you know what, I don't care if I get a dishonorable. One of the other things that I was thinking about last night too is that when we get PSIs, and I know you're also engaging in that bill, when we get pre-sentence investigations, we see criminal histories. It's very important for us to see criminal histories because we can get reversed if we don't have an accurate criminal history. But other states don't necessarily have honorable and dishonorable. We may not know the exact type of discharge. And it made me reflect on, it is important to the court to know if somebody has had a dishonorable discharge 4 times in Nevada, am I going to put them on probation? But if I kind of know, it's almost like parole. There's an other category. This needs to be an other category where I know, hey, they finished, they did it. It may not have been perfect, but maybe they are entitled to another chance at probation rather than prison. And what this does is it gives us discretion, because the bottom line is when an honorable and a dishonorable, it's not cookie cutter when it's in front of you and there's a person standing there and there's an attorney advocating for them and you're deciding, should I give this person an opportunity of probation? And if I do, I want to see them succeed. And if they don't, there's a consequence, but I don't think it should always be dishonorable if they haven't succeeded. So I didn't want to read the statute to you, but I think, and I'm going to invite your question and send an invitation back, perhaps those consequences need to be looked at a little further in a future legislature about what does it really mean to have the benefit of an honorable discharge as opposed to dishonorable.
Thank you so much. Our next question is from Assembly Member LaRue Hatch.
Thank you, Chair, and thank you for answering our questions. I actually would like to follow up on my compatriot's question, my colleague's question, because I don't think we actually got the details of what the difference is. I think you said there's discretion, but could you just give us some examples? In reading the statute, it seems like, in my reading, the only real difference is paying the fees back or not. So can you just explain the difference between honorable and dishonorable and what the actual consequences would be?
So honorable, as I think people, when they're reading along in this statute, they kind of go right over Section 2, subsection 1A. An honorable, a person is entitled to honorable discharge if they have fulfilled the conditions of probation for the entire period. They are recommended but for earlier discharge, or they have demonstrated fitness for honorable discharge, but the only exception here is economic hardship. And so what we'll get is we'll see in a petition for discharge, they can't pay it. I mean, and you can go back and ask for an actual financial statement, but they may be granted an honorable discharge. In other, then you see, basically it's written who's not entitled to that and has not made restitution or showed financial hardship. We have to always remember it's the overriding has not fulfilled all the conditions is a dishonorable. So then if you go down to 4, what would be new 4, a dishonorable discharge, or what we're proposing is general discharge, it does release the person from those obligations, except as provided in subsection 5. And so what it does is it releases them from any reporting. I mean, both honorable and dishonorable, you don't have to report in anymore. You aren't restricted in your travel. All the conditions, that's why I laid them out, because those are the typical conditions. And you're released from that except for your fines, fees, and you still have a civil liability. You would not if you were on an honorable discharge, because you would have paid it all, except if you've showed economic hardship. And then you have, you're free from the terms and conditions, which I think is one of the most important items. And then you're restored to your right to serve as a juror. 4 years after the date of discharge, you're restored to the right to hold office. 6 years, you're restored to the right to serve as a juror in a criminal action. The piece that I think that the overlay is sealing, and whether or not there's discretion if you have a dishonorable. And so I think this could be honed to subsection 6, but a dishonorable, you don't automatically get the benefits or presumption of sealing.
So just to clarify then, really the only difference is the sealing for the dishonorable. For the general, would they get the benefit of the automatic sealing, or would that be judge discretion, or how would the general?
Judicial discretion.
Okay.
And it accommodates that black widow situation where we're on the bench and I don't feel right about giving black widow a dishonorable.
And I don't feel right about giving Black Widow an honorable.
Thank you. Our next question is from Assemblymember Hanson.
Thank you, Chair. Thank you for being here. I would love to be a juror and hear you and your court give jury instructions.
There are no superheroes.
Regarding Section 2, let's see, Section 2, I think number 5, let's go there. Talking about, a little bit off of my colleague, Assemblyman Urick, where's the shift of responsibility going to be now for maybe a victim? To make sure I understand it right, a general discharge would not release you from unpaid fees, fines, assessments, or restitution. Did I understand that right?
It does release, except for as
Yeah.
provided.
It's that.
It provides for the fine, fees, costs, and assessment. Those remain a civil lien. I think that's where, and I can see in cases that's where there's a little issue with regard to releasing them and sealing, and it technically remains a lien. Under this language at the beginning, it actually can be subject to an action. So I think this is a nod to, they still have to pay the money, right? That there is a way to collect it. And that stays with them if they haven't shown financial hardship. If a person has truly financial hardship, the division will look at that and they will provide us that information. I think that some of my colleagues want a little bit more definitive information, rightfully so. So it remains out there. Does anything happen with it? I'm not sure it does.
Chair, can I have a follow-up? Yes. Thank you. So I'm glad you brought up the word lien. That's something I can relate to in our business practice. So is there an order that is restitution, like in the regular lien world, banks get in front of subcontractors and things like that?
Oh, that type of lien.
Is there,
Like
because
a
I'm trying,
mechanics lien?
yeah, I'm trying to have that kind of analogy. So does restitution come as a priority before fines and fees? Is there that kind of structure?
Yes, under Marcy's law, the amendment to the Constitution requires that restitution be paid before any other fines and fees. It puts a probationer in a little conundrum because technically you can't get your good time on probation if you aren't paying your supervision fees. You can't get to supervision fees until your restitution is paid. Now the division as a whole is treating it as if you pay your restitution, they'll still give you credit. They've created an internal policy. So under Marcy's law, it has to be paid first. Frankly, many defendants don't get to their fines and fees because of the restitution. And rightfully so. It used to be split pro rata. And so this put the restitution and victim restoration at the forefront. But you're thinking of, in your business practices, the equivalent to a mechanics lien that can be foreclosed on, right, under the applicable chapters. There isn't one specifically for this. And that is why I think that I don't think it's in this bill, it's in another statute. I don't have the number off the top of my head, but a judgment, and there is some proposed language that I think is coming before this committee, that a judgment can be enforced, a judgment of conviction can be enforced just like any other judgment. What that means is that it would have to go on the judgment rolls. Technically, you could record it, you could garnish on it, on an employer, and it would be paid back. I think that this language opens up that it isn't something that would necessarily only fall on a district attorney's office to pursue, but that it can be, an action could be filed independently, a civil action, for that restitution. And then you could go through that enforcement. Mechanics liens that you're thinking of, which is the term, even though it doesn't have to do with mechanics, I mean, it can, there is one for that too. There is not currently a statutory scheme to foreclose on this type of lien.
Thank you so much. We have a question from Assemblymember Gonzalez.
Thank you so much. Oh, thank you so much, Chair, and thank you so much for the presentation. I appreciated your example, also a Marvel fan. But in that example, what if the judge doesn't think that this person should be given that opportunity? And so I guess my question is, how do we prevent bias in this, or like what are kind of the safeguards around bias in this piece of legislation? Thank you.
I think that certainly I know that my colleagues make every effort to be fair. And in that example was that fairness to the Hulk, right? And the fairness to Black Widow. I don't think that you can legislate fairness. That is the third branch, and that's what we're entrusted to do. And there are other mechanisms for a judge that violates that or in any way treats people unfairly or inappropriately in their courtroom. But I don't think it's something you legislate. And it is something that gives us the avenue to do our job. We do it every day. We make really tough decisions. I made a very difficult one yesterday about whether to give somebody a chance at probation. And I hope I'm not wrong. But also, if there's an issue, and if it is an appealable issue, we have the Supreme Court to review us if it is appealable.
Thank you. Not seeing any additional questions, I will go ahead and open it up for testimony. Starting here in Carson City, if there's anyone that would like to testify in support of Assembly Bill 13, please come forward. Generally, yes, just in case someone comes up. Not seeing anyone, and I also don't see anyone in Las Vegas. Broadcasting, will you open the lines, please?
If you would like to testify in support of Assembly Bill 13, please press star 9 now to take your place in the queue.
Hi, my name is Yvonne Everlund. It's ESVERLUND, and I am in support for AB 13. I am a strong, as a direct impact individual like my son, who is recently released from parole, is on parole. While much focus is placed on the moment of release, what is not discussed is the chaos and hardships that follow. When my son was released, he faced overwhelming barriers just to regain his identity. He needed to apply for a state ID, birth certificate, and social security card, all essentials to securing employment. At the same time, he was struggling to readjust to society after years of incarceration. When walking into a grocery store, he would get overwhelmed with anxiety. I mean, grocery shopping is just a simple task, but he couldn't function. He held onto my hand so tight, my 30-year-old son. Why? Because the world felt overwhelming to him. How could he be expected to immediately start working when he was still learning how to exist in this new reality? Then came the $7,500 restitution bill, along with parole fees. How is it reasonable to expect someone who is incarcerated for 4 years to immediately pay off thousands of dollars? Who can afford that, right, after release? Instead of focusing on rebuilding his life, my son now carries a stress of an impossible debt. Worse, he was told that failure to pay will result in 10 extra days added to his parole per month and a dishonorable discharge. This is not rehabilitation. This is a trap. My son served his time for his crime. He is the Black Widow. He is working. He's programming. He just cannot afford the $7,500 restitution fee. AB 13 provides a necessary solution, allowing individuals on parole to work, make reasonable and highlight reasonable payments, and move forward without the constant threat of incarceration. I urge you to support AB 13 and help bring fairness and real opportunity to those who have already paid their debt to society. Thank you so much.
Thank you. Next caller.
Chair, there are no other callers to testify in support at this time.
Thank you so much. Then I will go ahead and open it up for opposition testimony. Okay, when this Friday it started wild. Now I don't know if, this is wild, but we're here for it. So please begin with your opposition testimony.
Thank you, Chair Miller, members of the Assembly Judiciary Committee. My name is John Jones, and I'm here on behalf of the Nevada District Attorneys Association. We are opposed to AB 13. I have had conversations prior to session with the Administrative Office of the Court and John McCormick specifically about our opposition to the bill. I appreciate the judge's presentation. However, the way that AB 13 is drafted would essentially allow the courts generally to neuter the dishonorable discharge statute. The way this reads, a court may, at its discretion, grant a person whose term of probation has expired, and this is the essential part, and is not eligible for an honorable discharge, they may offer them a general discharge. So a person could meet the qualifications of the dishonorable statute, and a judge could override the requirement to give them a dishonorable discharge and give them a general discharge instead. That is extremely important to us with respect to that. It is overly broad. It allows a judge to basically do anything they want to do with respect to people who aren't, by their nature, eligible for an honorable discharge. I'd like to make a second point. The statute right now allows a person who has an economic hardship that is verified by the division. That's the important part. Those individuals who the division has verified as having an economic hardship must get an honorable discharge if they have met the terms of their economic hardship and what the division says they can pay. I do have other oppositions that I'm happy to talk online. I do want to talk about the collateral consequences briefly, Chair Miller. In the past, prior to 2017, there were significant ramifications to a dishonorable discharge. You could never seal your records. You were never eligible to restore your rights, including jury service. The legislature got rid of all of those direct consequences of a dishonorable discharge. Really what we're using it for now is if they come back, we look at how they did when they were supervised before. That's the essence of it. And we still get a supervision history.
DA, we're over. Can you wrap it up?
Thank you. We are opposed. I am happy to work with the sponsor and the PDs to get to a support. Thank you, Chair.
Thank you so much.
Good morning, Chair Miller and members of the Assembly Judiciary. Paloma Guerrero, Paloma Guerrero. That is a strong ditto from my friend at the Nevada DA's Association, but for slightly different reasons. I do want to give some background because I think there's a lot of questions about just probation. So I want to talk about felony probation. When someone's placed on felony probation, usually the term is not to exceed 24 months. Towards the end, the probation officer will file what's called a petition for discharge, and that's something that goes up to the judge. And on this petition, the probation officer themselves makes a recommendation, either honorable or dishonorable. If the honorable's checked, that's just it. They're recommending honorable, and then we go up in front of a judge, the defense attorney, the DA, and then we make arguments. And it's ultimately at the judge's discretion whether or not to grant it. If it's a dishonorable, they'll list out the reasons why they're seeking a dishonorable, if that's unpaid restitution, unpaid fine, they had a positive drug test, they didn't have employment, whatever it is. But we still have the opportunity to argue if we think that person deserves an honorable discharge, and the judge still has a discretion to give that person an honorable discharge. And most of my clients are like Black Widow. No one's expecting every person to be absolutely perfect on probation. They come with issues. We try and address those issues. People take 5 steps forward, a few steps back, 5 steps forward, a few steps back. But if they complete probation, as a defense attorney, it's my job to present to the court why they still should get that honorable discharge, even if they weren't completely compliant. I think that general discharge just gives the judges a way out and kind of the opposite, it puts the honorable discharge at a much higher standard, which is a problem for my clients. I did also propose an amendment that I have talked to Mr. McCormick about and the DAs
And it has to do with when the probation officer is seeking dishonorable discharges based on unpaid fines and fees, not restitution, which has its own economic hardship provision carve out there, but just for unpaid fines and fees. But we can talk more about that with the sponsor and the parties and stakeholders. Thank you.
Thank you so much.
Thank you, Chair and committee members. My name is Nick Shepak, Nickshepak. I am the State Director of the Fines and Fees Justice Center. We appreciate very much the intent of this bill. Too many individuals who have an inability to pay their fines and fees are receiving dishonorable discharges. However, instead of creating a third category, we agree with our friends at the Public Defender's Office that there should be a path for individuals who have an inability to pay those fines and fees to receive an honorable discharge. The financial hardship if you will see in Section 2, the financial hardship only applies to restitution and not to those fines and fees. We conducted with Duke University a national survey on court fines and fees. These are people not only that are on supervision, but in general, 98% reported debt affecting their daily lives. 99% of parents had to cut back on at least one daily essential. 51% of impacted people had to cut back on 2 or more daily essentials. 35% of people who had fines and fees reported having food insecurity, and 27% reported having housing hardship directly related to their fines and fees. It is not the case that there are a lot of people who are willfully skirting these fines and fees, especially when on supervision, especially with the specter of a dishonorable discharge hanging over their head. So our only concern is creating this middle ground, puts a bunch of people who really are trying hard, who deserve this honorable discharge, possibly into a new category when there should be a path for these individuals who are doing everything they can to receive that honorable discharge. Thank you.
Thank you. Is there anyone else wishing to oppose Assembly Bill 13? Not seeing anyone in Las Vegas. Broadcasting, will you open the lines, please?
If you would like to testify in opposition to Assembly Bill 13, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in opposition at this time.
Thank you so much. Then I will open it up for neutral testimony. Is there anyone here in Carson that would like to testify in neutral? Not seeing anyone. Broadcasting, will you open the lines, please?
If you would like to testify in neutral for Assembly Bill 13, please press star 9 now to take your place in the queue.
Good morning, Assembly Chair, Assembly members, Jason Gibson, known as Angela Swift with the Galactic Federation, offering neutral testimony this morning. There's that number 13 again. Just listened in on this session and the testimony from the lady whose son nervous system has been destroyed. To remind you that all of this damage control that you're doing, because the state of Nevada incarcerates more people than any other NATO country in the world. All of this criminal economy that you're banking off of, and
sir,
so
we're
fond
asking
of.
you to speak directly to, your neutral testimony for Assembly Bill 13? So we're speaking
I'm
specifically.
getting to that, ma'am. Thank you very much. I'm getting to that. I'm bringing a solution to these kinds of bills,
Okay,
and that is
but sir,
start honoring your constitutional oath. I'm speaking directly to the bill.
which part of the
This
bill?
bill is being drafted. This bill is before this board right now because what you have is an identity crisis.
Okay, next caller.
Chair, there are no other callers wishing to testify in neutral at this time.
Thank you so much. Then I will go ahead and welcome the bill presenter back up for any final comments.
Chief Judge Lynn Jones speaking. Here's the reality. If this is not changed, it will result in more dishonorable discharges. The language in Section 2 is very clear, is not eligible for an honorable discharge and must be given a dishonorable discharge. So Black Widow at the end didn't have a financial hardship at the very end, was employed, right? She would have to have a dishonorable. I think that this is why I said, shift the paradigm, look at it from every angle. I also would just indicate the words that were used by the district attorney's representative was, we use this. It's past charging. It may be it's completed. It may be that it's at the time for their figuring out for negotiations. The judges use these discharges. It signals to me, if I were to see, when I prepare my notes, a general discharge, I'd be like, well, Black Widow did what they're supposed to do. So maybe I should give them an opportunity. And this gives opportunity to people. And it gets rid of the cookie cutter. And it gives the court the discretion it should have.
Thank you so much. Thank you for the presentation. With that, I will go ahead and close the hearing on Assembly Bill 13. Next, we have public comment. So is there anyone here in Carson City wishing to make public comment? Not seeing anyone here or in Las Vegas. Broadcasting, will you open the lines?
If you would like to provide public comment, please press star 9 now to take your place in the queue. Again, if you would like to provide public comment, please press star 9 now.
Yes, good morning again, Assembly members, Chair Jason Gibson with the Galactic Federation, Angela Swift here. This is a public comment opportunity. We are marveling at the dynamics of social reform this morning. And we just want to remind you that most of our superpowers have been stripped of us at birth when we were bonded by that birth certificate, that artificial identity, that AI. Yeah, that's what's going on here. It's an identity crisis, folks. Once people are self-realized and have an actual scientific pathway and an academic that's worth studying and learning from, then they will be naturally inclined to be properly informed about the opportunity of being a human being. But what you've got now is you have education that is rooted in commercialism, which is basically programming people for perpetual emergency, that time is money. The biggest complaint people have today is not having enough time or money. And folks are burned out on the corporate culture work week. It is a dead-end dog. It's a dead-end fiction. It's a ghost corporation. And it's not even a country. It's a bankrupt company called United States. It's broke as a joke. And you just keep throwing more money at it. Like you're gonna fix something. And until you discover the law of time and restore the American common law and actually begin to practice the Constitution, in order to form a more perfect union and start holding these public servants accountable to their oath and their pledge, nothing's going to work. So let's put into place the discovery of the law of time at lawoftime.org. Let's pick up our 13-moon, 28-day American Great Seal, and let's start getting real with the deal by getting informed by natural time.
Sir, your time
That's
is up.
at lawoftime.org.
Sir, your time is up. Thank you so much. Next caller.
You're welcome.
Anne Marie Grant, ANNEMARIEGRANT, sister of Thomas Purdy, who was deprived of his right to life and due process by Washoe County Sheriff and Reno Police. I'd just like to remind you all that police investigating themselves it's not transparency, and it certainly has never gotten anybody in the state of Nevada any accountability. People are still dying at the hands of police in your state. And I'd like to request that there is an NRS that allows an elected official to request an audit of any county jail. That needs to happen at the Washoe County Jail, so I please request one of you use your authority and please do that, because my brother was killed there along with 2 other men asphyxiated to death, and nothing has changed there. Thank you.
Thank you so much. Next caller?
Chair, there are no other callers to provide public comment at this time.
Okay, thank you. Then I will go ahead and close public comment. Thank you, everyone, for your work today in a very festive Friday meeting. And so with that, I will go ahead and adjourn today and see you all back at 9 a.m. on Monday morning. This meeting is adjourned.